If you are filing bankruptcy and you own a home, there is a term that you may have heard of that sounds scary but is often misunderstood. That term is called abandonment. Many people regularly assume that abandonment means they have to give up their home. In reality, abandonment in bankruptcy means that your home is protected. But when this concept of abandonment is misunderstood, it can lead to serious consequences. Hi, I'm Perlman. I'm a consumer bankruptcy attorney. We help individuals, families, and businesses get a financial fresh start. Before we talk about bankruptcy and the homestead abandonment today, I want you to understand that reaching out to a bankruptcy lawyer doesn't necessarily mean you're filing bankruptcy. It simply means you're trying to understand what your options are. If you find this video helpful, make sure to like, subscribe, and/or contact our office with any questions that you might have. When you file bankruptcy, everything you own becomes part of what's called the bankruptcy estate. This includes your home, vehicles, bank accounts, and personal property. In a Chapter 7, the trustee reviews all of your assets to see whether it's appropriate for him or her to sell assets that would benefit your creditors. If property has little or no value after accounting for your mortgages, liens, exemptions, and cost of sale, the trustee may elect to abandon your property. In New Jersey, in the context of a Chapter 7, the abandonment of your property is usually very good news for the homeowner/debtor. When the trustee abandons real estate, they have made a decision that there is no meaningful distribution that is available to your creditors. The trustee files what's called a notice of proposed abandonment on the docket, and if there are no objections, which is unusual, the abandonment becomes final. Once abandonment occurs, the property comes out of the bankruptcy estate and vests back with you, the homeowner. So, homes with no equity, vehicles with high repair costs, or vehicles that are upside down, or personal property that would cost more to sell than it is worth are common examples of areas where the trustee might abandon property. Once property is abandoned by the trustee, that decision is generally final. If circumstances change later, such as a foreclosure sale unexpectedly producing surplus funds, if the property increases in value, the trustee cannot reclaim the property or the proceeds unless there was a failure to disclose information in the bankruptcy schedules. Recently, I had a client who contacted me and the office about their abandonment. They were confused about how and when the trustee abandoned the property. I had explained to them that the abandonment that happened a year ago meant that the property vested back with them. They learned that their property had increased in value significantly, and they didn't understand, and they were confused about whether and if they had the ability to sell the property. Fortunately, after reviewing the docket and talking to the client, we educated them to let them know that they had a full green light to go ahead and list that property and sell it at their election, and the trustee and the bankruptcy estate had nothing to do with it. Ultimately, that closing yielded the clients excess funds of $100,000. Clients were delighted and really pleased that the abandonment worked out the way that it did. So, if you're considering bankruptcy and own a home, do not rely on mistaken assumptions or internet research. Bankruptcy law is technical, and small details can result in loss consequences. Remember, reaching out to a bankruptcy attorney does not mean you're filing bankruptcy. It means you're trying to understand your options and make an educated decision of whether bankruptcy makes sense for you. If you found this video helpful, make sure to like, subscribe, and share with somebody who you may find decides this video and content would be helpful to them. I'm Perlman. We look forward to helping you.